The title of my topic is Rights-Based Climate Change Litigation, but obviously because the water theme is so strong here, so I will make the emphasis on the water aspects in climate litigation. So just to share my screen here. Yep. Is that okay? So, so when we talk about climate change litigation and water, there are a few things that have to be mentioned. So first of all, what exactly is climate litigation itself? So as you all know, our impact, the impact of our economic activities on climate is simply huge. And it's so ironic that over the last several weeks during the lockdown, not just in the UK but globally, we've seen this dramatic drop in the levels of air pollution, the levels of environmental pollution in general. So the waterways are much clearer now as than they used to be. So we see the example of how our economic activities tend to, on a regular basis, how they tend to pollute the environment. Now, obviously, lockdown is not a solution to that, but it just simply shows that we can't pursue this business as usual model. So this is something that we have on one hand, and on the other hand, when it comes to climate change, we have all this international action, we have all this international agenda, we have the United Nations Framework Convention on Climate Change, we have the subsequent international acts, we have the regular meetings of the Conference of Parties. But the problem is that all this action at the international level and at the national level just seems to fall short of what is needed. So in other words, there are a lot of talks and there seems to be the developments seem to be constant. But at the same time, in terms of real progress, we don't see much of this. So that's where litigation, or in other words, courts, that's where they come in and where they try to make this difference. Rather not the courts themselves, but rather those individuals like you and me, or like non-governmental organizations who go to courts, who file legal cases and try to persuade the governments to take action, or they try to persuade, to have the polluters pay so that communities could adapt to the impacts of climate change. So climate change litigation is also an area of key research interest. It's becoming the area of key research interest. So one of the two major, so at the moment there are two major research centers. So one of them is Sabin Center for Climate Change Law at Columbia University Law School in the US. Now, this center specifically deals with litigations. This is something that I myself work on. And they maintain a comprehensive database of all cases in the world. The second center is Grantham Research Institute on Climate Change and the Environment at the London School of Economics and Political Science. Now, this center most focuses, or this institute rather, focuses on legislation, or in other words, acts, legal acts. What is international legal acts, or what is national legal acts. But for my part, because I look at litigation, so I will be looking specifically and will be using the databases maintained by Sabin Center at Columbia Law School. And sorry, can you see the database now?
No.
Okay. Does that work now?
Yes, that's clear now.
Okay, thank you. So, so that's one of the databases maintained by Columbia Law School. So it concerns climate change litigation in the United States. Now, the other database is the one that concerns litigation outside the US. Now, the reason for that, why this distinction, is not just because Columbia University is in the US, is that so far, from more than 1,500 cases, climate cases globally, more than 1,200 are in the US. So that's the reason for this distinction. So the US so far is this major, the jurisdiction with the most number of cases globally. And if we look at different types of cases, so we can see that because the US obviously is a federal system, so there are federal claims and there are state claims. But in the end, they're still quite similar. So we look at predominantly cases that are filed under the Clean Air under the Clean Air Act, or in other words, under the air quality legislation. And the other major group are cases that concern environmental impact assessment. Now, these are brought under the National Environmental Policy Act. And once again, the scope of these cases. So when you look at clean air legislation, so you have cases such as, for example, challenges to, say, to agency decisions when it comes to whether to regulate certain pollutants as greenhouse gases. And in fact, one of the major cases in the US was brought by the state of Massachusetts and a group of other states and non-governmental organizations against the Federal Environmental Protection Agency, because Massachusetts and those other plaintiffs, they tried to persuade the agency to regulate carbon dioxide, which is one of those most common greenhouse gases, under the air quality legislation. And obviously the Environmental Protection Agency said that we don't have a mandate for that. Now, this is one of those examples where the Supreme Court, because the case went all the way to the Supreme Court, so the Supreme Court made this real difference by saying that that carbon dioxide falls under the category of air pollutants and has to be regulated under the air quality legislation. So essentially giving the mandate to the Environmental Protection Agency to regulate it. In terms of environmental impact assessment cases, so this is the broadest category, and it includes cases such as, for example, challenges to permits to build new power plants or to expand mines. And this is a very broad category of cases, and by the way, this category of cases is the same one which is most common not just in the US but globally. So for example, in Australia, there were a lot of cases that are brought against the regulatory bodies who issue permits to develop, say, coal mines, and obviously coal mines is a huge problem in Australia. The development of those coal mines is a huge problem in Australia. And also, talking about Australia, so it's also interesting, and I'm finally getting to the issue of water, how those greenhouse gas emissions, how they are linked to, and the impacts of climate change, how they're linked to water. So in the US, you see that there is a small, very small category of cases that fall under the Clean Water Act. Now, those cases so far, most of them, they're very new, and courts still, most of those cases, they still haven't been addressed by courts yet. So most of these are just lawsuits, and courts haven't decided yet. But elsewhere, so for example, in Australia, those cases that concern environmental impact assessment and those coal mines, they quite often link the impacts of climate change and the greenhouse gases from those coal mines to the impacts on water, namely the Great Barrier Reef. So as you know, in Australia, this is a huge problem with coral bleaching. So this is one of those examples. But I myself, I specifically wanted to focus on two other categories of cases. So I wanted to focus on the so-called public trust claims, and I wanted to focus secondly on the adaptation cases. So in terms of public trust claims, let me just go back to the presentation. So in terms of public trust doctrine cases, these are cases that require government to hold vital natural resources in trust for the public beneficiaries, thus protecting those resources from monopolization or destruction by private interests. And this doctrine itself is not new. So initially it developed back in Roman times, and then it moved into the English law during the medieval times, and finally it settled in American law. But if we look at American law, so we're looking at the original doctrine back in the 19th century. And according to that doctrine, so it covered, as a vital natural resource, it covered only navigable and tidal waters and the land submerged beneath them for the purposes of navigation, commerce, and fishing. In other words, for those social economic activities at that time. But the important thing is that because public trust doctrine is part of common law, which is a very flexible system, so it evolved. And in the 20th century, courts started expanding the doctrine to cover wildlife, to cover ecosystems, non-navigable waters, parks, and beaches. And this time it was for the purposes of recreation as well as ecological preservation. And finally, when it comes to climate change, we get to 21st century. And the question is whether we reach this point when we have to declare the very atmosphere a public trust resource. So in other words, whether we can put an equation mark between water and the atmosphere. And this is the approach that was championed by this lady here, Professor Emerita Christina Wood of Oregon University, who stated that in order to protect the planet from climate change, we need to declare that the atmosphere is a resource just like water, just like wildlife, and we need to protect it from greenhouse gas emissions in order to stabilize our climate. So this is what lies at the core. This is what lies at the core of those so-called public trust doctrine-based cases. And we see that those cases, they've been developing since May 2011, which is quite remarkable. Because you see, in this type of litigation, the plaintiffs are children. So typically when we think about children, we think about Greta Thunberg, we think about Extinction Rebellion, so Fridays for Future, so something very new. But in reality, the first action initiated by children dates back to nearly a decade ago, to 2011. And it was a nationwide campaign when children were obviously, through their guardian, through their parents, started petitioning various US agencies to initiate rulemaking to address GHG emissions. And that's what these cases are about. And throughout this decade, those cases had mixed success. So just to give you two different views adopted by courts in different jurisdictions. So, for example, the court in Oregon, in one of those cases, said that the atmosphere does not present the concern of being exhaustible and irreplaceable in nature, because it's not the type of resource that can only be spent once, although it can certainly be polluted or otherwise changed. So essentially, this is a very different, so in other words, this view puts atmosphere into a very different place rather than navigable or non-navigable waters. But then you have this directly opposite view of the court in Washington that stated that the navigable waters and the atmosphere are intertwined, and to argue a separation of the two, or to argue that greenhouse gas emissions do not affect navigable waters, is nonsensical. So in this case, the court essentially put the quotation, so literally equated navigable waters and the atmosphere, so saying that this is a resource that has to be equally protected. So this is one type of cases that I myself am mostly interested in, because these are cases directed against the governments, and the overall goal of those cases is obviously to force the governments to regulate greenhouse gases. So in other words, it's climate change mitigation strategy. And by using this ancient doctrines, public trust doctrine, which traditionally involved around water issues, bringing this doctrine to cover the atmosphere is this new strategy. So another type of lawsuits that I'm also very interested in. So this lawsuits concern adaptation. Now this photo, it shows all this devastating flooding caused by Hurricane Harvey in Port Arthur in Texas back in August, September 2017. And you see all the devastating damage caused by the flooding. So you see thousands of homes, thousands of buildings, all this property is simply ruined, destroyed. And so this was quite recently. You may know that after Hurricane Katrina back in 2005, there was still a lot of property that is still just being destroyed, that is still left practically destroyed in New Orleans, Louisiana. So essentially, this is a long-term destruction of private property. And this is what the adaptation lawsuits are targeting. So they can target authorities, they can target the governments by claiming that the government's not doing enough to protect those properties, to protect the property from all this impact from the flooding. And in those cases, the plaintiffs, once again, they're looking at environmental impact assessment legislation. And essentially, they're looking at legislation covering water, because this primary impact is from water, is from flooding, it's from rising sea level. Another group of the same adaptation lawsuits concerns litigation against private emitters. Now, this is something extremely complex, and once again, it's something very new. Because when it comes to private emitters, you know that there is this problem of who exactly is the private emitter, because to a certain extent, all of us are private emitters. So those of us who drive, obviously we use energy for our household and so on. But on the other hand, you have all those major corporate emitters and the providers of fossil fuels, such as Exxon, such as BP, Chevron, Shell, and so on. And the problem is that the issue is that those private emitters, obviously the extent to which they contribute to global greenhouse gas emissions can be compared to the impact of individual citizens. So, and also what we know from the evidence obtained by scientists is that those companies were already aware of the risks associated with the use of fossil fuels back in the 80s or even 70s. And not only did they ignore those threats, but they actively engaged in this public disinformation campaign and aggressive lobbying and trying to prevent any action from taking place. So one of those theories is that we should hold those super large private emitters such as Exxon, such as Chevron, BP, and Shell, that we should hold them liable and to seek compensation from them. So in other words, that they could help cities become more resilient to, for example, sea level rise, right, to prevent all this flooding like happened in Port Arthur. And this strategy is pursued mostly by cities themselves. So so far, a lot of states in the US, a lot of cities have already brought those claims against those large corporate emitters, those large fossil fuel companies, and they seek liability. But needless to say that those cases will need to go through a very complex legal scrutiny, and how courts will assess these cases, how courts will judge these cases is still something very difficult to predict. But so far we see that this link between water and the atmosphere and between the emissions is becoming more and more important in climate litigation. So so this is essentially the area that I'm mostly interested in, and this is something that I work on. And I would be happy to answer any of your questions on this. Thank you.